596. The defendant is present with counsel Chad Mulkey. We're here today for a change of plea hearing. It's the state's understanding the defendant is going to withdraw his previously entered plea of not guilty and enter a guilty plea to count one, failure to comply, a felony of the third degree. There is no agreement as to sentencing, and the state would ask for a pre-sentence report. Thank you.
Mulkey, does that all sound accurate?
It does, Your Honor. And then after the change of plea, we also ask to be heard on bond respectfully, too. Thank you.
Okay. Mr. McRae, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to the charge in the indictment. And I'll go over that with you to make sure you understand that. We would then continue the sentencing to a later day to get an evaluation completed, come back on a future day for sentencing, where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you need a moment to talk to your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? All right, let's get started then. How old are you, sir?
28.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, you would have been served with and received a copy of the indictment in this case. Looks like you got that, not that long ago, just a couple weeks ago. Remember getting the indictment that sets forth the charge?
Yes.
You had a chance to look that over?
Yes.
Now, in that indictment, you are charged with one count. And what's alleged in this count and what you're going to be pleading guilty to is on or about December 14th, 2025, originating in the city of Willoughby, Lake County, Ohio, and culminating in Cuyahoga County, that you did operate a motor vehicle so as willfully to elude or flee a police officer after you received a visible or audible signal from the police officer to bring your motor vehicle to a stop. It's further alleged that your operation of this motor vehicle caused a substantial risk of serious physical harm to persons or property. That conduct constitutes the offense of failure to comply with an order or signal of a police officer, and it is a felony of the third degree. Do you understand what you're charged with and pleading guilty to in regards to count one?
Yes, Your Honor.
Any questions about that?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. 1 second. All right. Now, first off, you have a right to have a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision. Unanimous means that all 12 of them would have to agree together, one way or the other, as to whether you were guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we call the burden of proof. With her having the burden of proof, what that means is that it is her job, or she bears the responsibility or the obligation to prove you guilty before you can be found guilty. You're presumed innocent of the charge. The presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. You understand that?
Yes.
Now, when we speak about this burden of proof, since this is a criminal case, that burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge I just read to you beyond any reasonable doubt before you could ever be found guilty of the charge at a trial. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, the prosecutor would bring witnesses into the courtroom to testify for the state, and they'd answer by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. So he would be allowed to ask him anything he wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
You realize you're giving up that right.
Yes, Your Honor.
Now, you also have a right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision. That's a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody can compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But more importantly, the prosecutor here is now allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up any right you have to appeal a guilty finding that I will make if I accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts that are being alleged by the state. We're not going to argue you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, pleading guilty to a felony of the third degree, this particular felony of the third degree carries with it a possible term in prison of a minimum of 12 months, a maximum of 60 months, or increments in between of every 6 months. So 6, 18, 24, 30, etc., all the way up to 60 months. Do you understand that?
Yes.
Now, are you currently on probation or parole or any supervision in any other courts or agencies?
No.
Do you have any other criminal charges pending against you anywhere?
No.
If a prison term is imposed in this case, there's two possibilities here. At a minimum, you could be put on what's called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence, and it could be for up to 2 years. You understand that?
Yes.
Now, if the court were to find, I don't know anything about this case at this point, but if the court were to find, based on the facts, that this is an offense of violence, then post-release control would be mandatory if you went to prison. First of all, an offense of violence means that it's an offense which was committed purposely or knowingly, which this offense is that you're pleading guilty to, which involves physical harm to persons or a risk of serious physical harm to persons. So the offense you're pleading guilty to, what makes it a felony of the third degree is that it created a substantial risk of serious physical harm to either persons or property. To be an offense of violence, it has to be to person. So if the facts in this case only show that there was a substantial risk of serious physical harm to property and not to any persons, then it wouldn't be an offense of violence. If it also includes a substantial risk of serious physical harm, not even a substantial risk, just a risk of serious physical harm to a person, then it'd be an offense of violence. And if it's an offense of violence, then post-release control is mandatory for at least 1 year, and it could be up to 3 years, and it's up to the parole authority to decide how long. You understand that?
Yes.
Now, if you are on post-release control at any point for this case and you ever violated any of the conditions or rules of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
Now, aside from the possible prison sentence that I just mentioned, there's other sanctions that can be imposed, some that will be imposed. There's a possible fine in this case of up to $10,000. I could also order that you pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment. And I can also order restitution of any victim for any economic loss or damage that any victim may have suffered as a result of the criminal conduct you engaged in. Do you understand that?
Yes.
Now, there is a mandatory license suspension. The defendant doesn't have any priors on fleeing and eluding charges?
That's correct, Your Honor.
So in this case, there's a mandatory license suspension I'm required to impose of at least 3 years at a minimum, and I could suspend your license permanently for life. Do you understand that?
Yes, Your Honor.
And with that suspension, you're not entitled to any privileges for at least the first 3 years of any suspension. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory with this charge. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're requesting. I'm going to look at all the information that gets presented to the court. Then I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
If you are put on probation, it could be for up to 5 years of supervision. As the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be in order that you serve time in the Lake County Jail of up to 6 months as a condition of your probation. You understand that?
Yes.
Further, if you are on probation and you never violate any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years. It wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison, again, it could be 6, 12, 18, 24, 30, 36, 42, 48, 54, or 60 months in prison. You understand that?
Yes, Your Honor.
And that also could be consecutive to any other prison sentence you may be serving for some other case, or that you're being sentenced to at that time for some new case. Do you understand that?
Yes, Your Honor.
Lastly, when we do proceed to the sentencing hearing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer can speak on your behalf. Recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer, have him review the report with you, discuss the issues, answer any questions you may have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced at all in any way to enter this plea of guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this time regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No.
Do you need any more time to talk to your lawyer before we go forward with your actual plea of guilty?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show or establish at a trial, if we had a trial. I want you to listen to her because I have some questions for you about that, all right?
Yes.
All right, Ms. Bell?
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on December 14th, 2025, the defendant was driving his vehicle in Willoughby, Lake County, Ohio. He was pulled over by Officer DeSanto on Ridge Road in Willoughby. Officer DeSanto used his audible signal and visible lights to bring that vehicle to a stop, and the car initially did stop. Officer DeSanto exits his patrol car, walks towards the defendant's vehicle and stands beside it on the side of the road. At that point,
Where is this at?
Ridge Road in Willoughby, so 84, by Breckenridge-ish.
Okay. But it's on 84?
Yep. While the officer is standing on the side of the road, the defendant then takes off down 84 towards I-90. The operation of that motor vehicle caused a substantial risk of serious physical harm to persons or property. Specifically, again, it was December 14th. There was snowflakes in the air. It was 10:20 p.m., so it was dark. The ramp to I-90, the entrance ramp, was covered in snow. The rest of the roadway wasn't, but that ramp was covered in snow. And the defendant reached speeds exceeding 105 miles per hour on
Where?
I-90.
On
On
the
I-90,
freeway?
which is a 65 mile per hour zone. The officer eventually loses sight of the defendant in Euclid around the East 200th Street area. That pursuit lasted for 2.9 miles.
Well, I note that this happened in December, and then a warrant wasn't issued until March from municipal court, the probable cause warrant.
That's correct, Your Honor. There was a lot of investigation on the back end finding the identity of the driver. That did not happen at the initial stop.
Mr. McCray, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if you had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do as she said?
Yes, Your Honor.
Very well. Regarding count 1, charging with failure to comply with an order or signal of a police officer, a felony of the 3rd degree. What is your plea to that count?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything we've just discussed. Before I can accept your plea, I need to make sure you can understand this document, that you sign it here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes.
Mr. Mulkey, is that accurate? Did you review this with your client, read it to him, answer his questions?
Yes, Your Honor.
And did he indicate that he understood this document when you were going over it with him?
He did, Judge.
Is that correct, Mr. McCray? You understand the document?
Yes.
Any questions for me about what it says?
No.
It also appears you signed the document. Did you sign it?
Yes, Your Honor.
You witnessed that, Mr. Mulkey?
I did.
You as well, Ms. Bell?
I did, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, failure to comply with an order or signal of a police officer, a felony of the 3rd degree in violation of 2921.331B. The first sentencing, I'm going to order a pre-sentence report and investigation. You wanted to be heard on bond, Mr. Mulkey?
Please, Your Honor. Your Honor, I talked to my client. He's indicated that he resides at 756 East 133rd Street in Cleveland, Ohio. He lives there with his mother and his brother. His mother can provide him reliable transportation to court. He's lived there approximately 14 years. He also has 2 daughters that reside in Cleveland. Now, they don't stay with him, but he gets to see them fairly often, a 1-year-old and an 8-year-old. He'd like the opportunity to be released from the jail on a recognizance bond to demonstrate to the court that going forward, he would be suitable to probation, and by doing so, he would not risk getting his bond revoked. So he'd like the opportunity to demonstrate that to the court, to maintain his residence at that address, stay out of any future entanglements with law enforcement. He understands, and I've told him that by asking for a recognizance bond, that would invite a new felony charge for not showing up to court. He fully understands that. He'd be willing to wear a GPS and follow any and all other bond conditions. As for a record, he's never been to prison before. He does represent to me that he does have a prior felony DV, and I believe there may be a prior failure to appear in 2017. But other than that, he's indicated that he will show up to court, abide by all the court's conditions of bond, and cooperate fully with probation for his pre-sentence report. Furthermore, he indicates that he is skilled at, he does cleanup work at casinos and restaurants. I think there's an app that you can get on your phone. When jobs become available, he can do those jobs. It can be provided transportation via Uber, Lyft, or his mother, because he wants to make money so he can continue to support his children, Judge. So for those reasons, we'd ask the court for a recognizance bond, or in the alternative, a low cash bond. If the court does set a lower cash bond, he did indicate he would have to talk to a big bonds person for that. So he'd like to not have to do that if that were possible. Thank you for your consideration, Judge.
Ms. Bell for the state.
Thank you, Your Honor. The state would recommend that his bond be continued at $250,000 cash surety with the GPS monitor if that bond is posted. Mr. Mulkey did not give an exactly complete view of the defendant's criminal history. In 2015, he also had an F2 robbery. And in 2022, there seems to be a falsification, obstructing, and endangering children charge as well. He currently has a probation violation warrant out of Cleveland for those 2022 cases.
I asked if he was on probation. He said no.
That's just based on my,
I know, keep going. I'm not questioning you. I'm
Okay.
questioning if there's a warrant. Why wasn't he on when I asked if he was on probation? You're on probation?
Yes,
Well, why'd you say no when I asked you that?
because I didn't have a warrant for that.
What, sorry?
I didn't have a warrant for probation.
But I asked you, are you on probation? And you said no.
I thought you were speaking as in Lake County, like.
Okay. Well, I gotta make sure you understand something. If you're on probation when you commit a new offense, there could be consequences with that court. Nothing I can do about it. I can't add any time or anything like that. But there could be consequences there for as a probation violator for committing a new offense while you're on probation. You understand that?
Yes.
Does that change your thoughts about this at all?
No. But could I say something though? The 2015, I was a juvenile with the F2 robbery. I was a juvenile when that happened.
Okay. But you did it, right?
Yeah.
As a juvenile? Go ahead, Ms. Bell.
thank you. And that probation warrant has been active since 2022. There's also a warrant out of Kent for a failure to appear. Also, just based on the allegations in this offense, it's very clear that Mr. McRae has trouble following the rules, especially when it comes to law enforcement. So the state does believe that the bond as set by the municipal court is
There's a warrant out for failure to appear?
from Kent. Yep. Thank you.
Bond's going to remain at $250,000 cash surety.
All rise.
Your Honor, we're here today in the state of Ohio versus Devin Lewis, case number 25CR1222. The defendant is present with counsel Jim Matthews, and we're here today for a sentencing hearing. We were last before you on April 2nd, and at that time, the defendant pled guilty to count 1, improper handling a felony of the 4th degree with an attached forfeiture specification. During that hearing, a pre-sentence report was ordered that has since been completed, and the defendant has 41 days of jail time credit. Thank you.
Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank you. Your Honor, we are asking for community control for Mr. Lewis. He's 26 years old. He does not have an extensive criminal history. I do understand that he does have an extensive traffic history and a history of failing to appear for court hearings. This is something I'm sure Mr. Lewis would like to address directly with the court when he's speaking. However, we do feel that the 41 days that he has been in jail certainly has gotten his attention, and he does intend to take seriously whatever orders this court does give him. We do feel that given the fact that, yes, he did test positive for drugs, and also given the extent of his criminal history that services to address both any substance issues as well as issues relating to decision-making, handling of his affairs going forward, could also be addressed on an outpatient basis with the Decision Point program. Thank you.
Give me 1 second, please. Mr. Lewis, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, I would like to read something about this paper.
Sure, you can do whatever you like.
First and foremost, I would like to say Happy Memorial Day to everyone, and I hope you guys enjoyed your weekend. Secondly, Your Honor, I do pay rent. I'm recently engaged. I don't want to lose my future because of my past. I understand I have an extensive driving record, and it may seem irresponsible, but I was young. I started driving at like 17, 16 years old, going back and forth to college at Akron University. I picked up my first driver in suspension then, I think with Portage County, something like that. I didn't have a license.
You were young. That's your excuse for driving under suspensions?
No, that was my first driving under suspension was when I was young. And I've been picking them up ever since. I've done 30 days, between 3 and 30 days jail time. I've been doing community service.
And that obviously doesn't work. But go ahead.
Yeah.
I'm not laughing.
No, I understand.
It's so disrespectful. You don't give a shit what any judge says. You do what you're gonna do, but go ahead.
They constantly ask me to try to get my driving license. I actually don't know how to do that. I know I have a bunch of fines to pay. I do have some warrant blocks to clear as far as that driving record goes, but my criminal record in general just is starting to get outstanding, and it's actually not me. I have an aggravated menacing conviction, which is a misdemeanor. I did 8 hours of anger management for that. I have a CCW misdemeanor in Cuyahoga. I'm currently serving 1 year of probation on that. I haven't missed any hearings. I've been showing up every since. I'm currently facing an improper handling charge with you guys. I don't know what my future holds with that sentence. And then the driving and suspension, like I said, those are getting handled shortly but surely. Those are the least important to law or whatever. They kind of sweep over them or give me 3 days jail time, which isn't penalty to me, but over 30 days and me being here past 40 is the longest I've ever been in jail. I do pay rent, I do work, I am employed. I don't want to.
Who you licensed through as a security guard?
I was supposed to get my CCWs with my probation department, and then as far as the company.
No, you said you're a licensed security guard.
Yeah, licensed armed guard.
So who you licensed with?
I was licensed with 2 different companies. Excalibur was one of them, and then currently I don't know the name of the company. It's like private, but
What does that mean to be a licensed security guard?
Before without my felony conviction, I was just allowed to own or possess a firearm, and with me like being like qualified to work and do so without no aggravated or violent crimes or history. I just do security and armed guard for like the Cavaliers, the Browns players, people, artists, clubs, smoke shops, something like that, of that result. And when I show up with my private investigator card or guard card, that's what I call it.
You show up what?
Like my private investigator or guard card. I don't have my APATA, so I won't even be able to like work anymore with the felony conviction. It's revoked. But yeah, I'm just trying to find a good career with myself. I can do warehouse work. I can do warehouse work. I can do construction certified, plaster and cement mason, carpenter. I don't have to do security. I just fell in love with it, and it was the most responsible job for me. I was coming home from work today. I got pulled over, so it's just, I looked at it as a career path. And then I will obey any conditions set upon my bond or sentencing today. I will stay in contact with my officer and attorney, and I will continue to pay any fines. And like I said, take care of any warrants I have. Cleveland Heights is one of them.
Yeah, but you don't. You say you're going to do that. You don't do that.
I really don't.
You have 1, 2, 3, 4 failure to appears for the probation that you're on in Shaker Heights right now. You don't go.
No, I'm not on probation with Shaker Heights. They gave me 8 hours of anger management. I was supposed to complete that class, in which I did.
You were on probation and you failed to appear in February of 25, May of 25, June of 25, September of 25. And then in October, they put you on 6 months of probation with 10 days of jail, anger management, and that may be done now. Let's see, November, December, January, February, March, April. So that's done now. My point was, when you were on probation, you never went. You never reported. You didn't show up. You got violated.
I never understood the stipulations of that being like
Well,
my first.
then probation may not be for you, because if you can't understand the fact that you have to go to
I'm on
report.
probation. I'm on probation now with Cuyahoga, and I have been reporting. My officer name is Noah Reed.
And you got a violation for failing to report in February.
That's because I was arrested here.
And you got another probation violation. Oh, no, the hearing was in March.
And they retook that back. They found I wasn't guilty of violating, and they re-enlisted it, and I'm currently on probation.
Go on. You can continue.
Oh yeah, I was saying like that's when I got arrested in here, and then they questioned me about it. They was like, "What was the violation for?" And I was like, "I got arrested here," and then I went to Lorain County. When I got out of Lorain County, I contacted my probation officer. It switched from the Miss K to Noah Reeves. I met with him, He got my evaluations, and I've been reporting ever since. I have his contact. My attorney has his contact. I've not played about probation since I've been on the actual probation, not the 8 hours of anger management, not that actual probation, going to the department, meeting with the officer. The drug screening here, I knew it was in my system. So
Well, you didn't tell me that when I asked you if you're using drugs or alcohol in the last 48 hours. You said no.
Not within that day, but within that month. Like, I know
You used it the day before you came here. That's what you told probation. You said you used it April 1st. The last time you used it, you said it was April 1st, and I believe we were here April 2nd. Let me make sure of that. I could be wrong.
I used it the day before I showed up.
Yeah.
Probation.
Your plea here was April 2nd. So you were here in court on April 2nd. And you told the probation department when the last time you used drugs, and I believe it was April 1st, he stated that he last used marijuana on April 1st. You were here April 2nd. And I said, if you used any drugs or alcohol in the last 48 hours, you said no.
I probably didn't remember saying that within the 24 hours, but I did regularly smoke marijuana throughout the week. I just didn't do it like daily or nothing like that.
And then you did it after you left here, even though you were told you can't do it. It's a violation of your bond. You're going to get your bond revoked, and a warrant's going to be issued if you do. And you did it anyway.
And I did not understand the bond stipulation said, even when I first got arrested.
When I specifically said one of the conditions of your bond is that you can't use drugs, you're going to have to submit urine screens. And if they test positive, your bond will be revoked and a warrant will be issued for your arrest. You don't understand what that means?
I do now. I do now. It happened.
I guess my concern is that if you don't understand a condition like that when I say it, you ain't making it on probation.
Yeah, I've never been on probation. I never have.
What do you mean you've never been on probation? You're on probation when you did this.
I meant like on this stature, like a felony. I had the marshals come pick me up for a warrant I wasn't aware of. Like, it's just a lot been going on since I came out here to this county. I know you guys are very serious and very strict. I'm not laughing. I just want to think the most positive outcome of this and just keep a smile on my face. But I take all of this serious. I've been in contact with my attorney. I've been in jail. I have not been messing up. I just really want the best outcome. Even if it's, I don't even know about probation. It's, you guys know about it more than me. I just know I have to show up. I met with my officer downstairs, beautiful, just nice person, but she told me straight up and down, she was like, yeah, you're going upstairs. You tested positive. I'm going to submit another drug screening within 40 days. I'm pretty sure it's out of my system now, and proof will show that I don't have to consume any type of drugs. No miles, no smoke, no drinking, nothing. I don't have to consume anything. I'm clean. I can get tested today. I've been in jail.
Well, yeah, you've been in jail for 40 days.
Yeah,
that's what was necessary for you not to use.
Yeah, and
to comply with your bond.
And I will not use. I will not. I won't violate any bond stipulations. I will show up. I just want to be responsible. I don't want to be irresponsible. I want to be truthful. I didn't understand the conditions. I'm truthful with that. I didn't understand.
Do you not understand that you're not allowed to drive without a license?
I did understand that, but I was trying to get my license. So me buying a car, me trying to get it registered, me having insurance, me knowing that I don't have a license. 16
convictions. It's not one. You have 16 convictions for driving under suspension. I've never seen this before. Never.
Yeah, my driving record is.
Well, that's nothing to be proud of.
Oh,
responsible. You say you're responsible. That's as irresponsible as you could possibly be.
Yeah. And I paid for it every day. I did 16 days in Lorain County for one driving under suspension.
Well, apparently it's not deterring you.
Oh.
It's not having the effect it should, because you get right back in the driver's seat.
I haven't drove since August, and I won't drive again. I don't need to drive. I catch the bus out here. I caught the bus out here to be in jail for 40 days. I'll be catching the bus back home. I don't need to drive anymore. That's the trouble within itself. It's got me in a lot of trouble. 90% of these violations that I have started with me being behind the wheel, even regardless of where I was going or coming from. I don't understand that. I won't drive anymore. I have been showing up to probation. I wasn't getting tested there, so I wasn't understanding the stipulations of being tested here. I'm no longer intoxicated. I don't have anything in my system. I will test here as well. I just really want to show like.
So here's a question I have. You said that you didn't know you were allowed to have weren't allowed to have a firearm because you're a security guard, private investigator, and it's part of the job, and you said you didn't know you weren't allowed to because you need to have it for your job.
Well, now I do. I have a felony now. That's a penalty.
All right, but what about before? You had been arrested and charged with improperly handling a firearm in a motor vehicle in Cuyahoga County, and you were on bond for that when this happened. So you've been charged?
I had got charged.
Don't tell me
No, I promise. I got charged afterwards. I got arrested in August. I got convicted in October.
You were convicted in October. You were arrested for it and charged with it before that.
I was never arrested. They pulled me out the car in March, and then they let me go, and my boss came and picked me up. But I was never arrested that day, or throughout that whole. The charge had opened in March, and I didn't hear back from.
The offense happened in May of 25.
Yeah, May. I mean.
You're saying you weren't arrested then?
I wasn't arrested in May. I was out all this time, and then I found out about the charge again in August after I got arrested with you guys. I found out that they recalled it, and now I got to go to court for it. I went to court for about 2 weeks, and then they gave me the conviction. And I understood the stipulations that they said. They said I got to show up to court, show up to the probation department. It's on a certain floor. It's going to be different from Shaker. Shaker only had to complete that class. Once I completed that class, I got a certificate, and I wasn't on no type of holds or probation with them anymore. So this is my first time being on probation with Cuyahoga, and I've been taking it very serious, Your Honor.
You didn't show up for 5 straight months.
I wasn't available. Nothing was set. Nothing was open. No court date was set. Nothing was like that. They recalled it.
Go on.
Yeah, they had recalled that case, and
They didn't recall that case.
it happened in May. They recalled it.
I'm not talking about that. I'm talking about probation to Cuyahoga County.
Yeah, they set the conviction as a they dropped the CCW and improper handling. They only charged me with a CCW misdemeanor. Originally was a CCW felony.
Right, and you were put on probation
For a year. So
I'm talking about in Shaker Heights. You were on probation to them.
Yeah.
In 2025, you failed to appear 5 times, 5 straight months.
Yeah, I didn't know nothing about the act. I didn't have a reporting officer. Oh, I had an officer, and I reported, and she put me on 8 hours of anger management. I didn't have to report weekly or daily or monthly.
That was after they finally arrested you in September of 25. After you didn't show up in February, May, June, and September.
Yeah, I'm not. I don't. I remember.
I'm not going to keep arguing with you.
I remember it happening though. I think her name was Graham, Officer Graham.
You can continue if you'd like.
For now, that's it. I do agree with not smoking, not drinking, not driving, no firearms, no violence, just no criminal activity whatsoever. I do pay rent. I'm behind on rent for 2 months. I just want to get back to work and try to figure something out. It doesn't even have to involve a firearm. I can do surveillance and watch a camera all day or something. But I just want to be able to get back to work and get back to my home. I know jail is not for me. I may have messed up with probation stipulations or not understood them in the past. They're very clear to me now. And this is the strictest of all my crimes. A felony. I've never had a felony before, and I take this felony very serious.
All right, you can be seated if you're done.
Thank you.
Mr. Matthews, anything else?
No, Your Honor.
Ms. Bell for the state.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and the state certainly has some concerns. The court has alluded to the fact that the defendant doesn't seem to want to follow the rules, follow the laws. You know, the 16 driving under suspension in 7 years. He violated his bond by testing positive for marijuana twice, not to mention he was on probation when this offense occurred. Based on that and just his cavalier attitude during his pre-sentence report, it doesn't seem like he believes that this to be a big deal. The state would recommend NeoCap. Thank you.
This court has reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. And I've considered what's been said here by the defendant, his lawyer, the prosecutor, the recommendations. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-2911 of the revised code. For the factors in 29-2912, nothing stands out factually indicating the conduct is more or less serious than what normally constitutes this offense. As for the recidivism factors, many of these are present. The defendant was on probation at the time he committed this offense. He has a history of criminal convictions. He has failed to comply with previously imposed sanctions ordered by courts, not just prior probation violations, but as I alluded to, he's got 16 convictions in the past 7 years for driving under suspension. So a judge has said, your license is suspended, you can't drive, and he goes about and drives anyway. He violated his bond by smoking marijuana and using drugs while on bond. Those are all factors indicating recidivism is more likely. He also has multiple, the probation violations are for failing to appear multiple times that he did that. No factors indicate recidivism again is less likely. Under 29-13B1, the defendant was on probation at the time, and the offense also involves a firearm, which overrides any presumption for community control and permits the court to impose a prison term. I will find at this time, however, that prison is not consistent with the purposes and principles of sentencing. And I'll make a finding defendants amenable to community control sanctions. I have some serious reservations about that because your history is that you're going to do whatever you want to do. It doesn't matter what a judge says or what anyone else says. You're going to do what you want to do. I'll give you the chance to prove that's not you. I'm just saying your history shows that is you.
I appreciate that.
Um,
But I'll give you a chance to prove it. But I'm not going to play these same games that I've been playing with everybody else. I can assure you of that.
I understand.
I'm going to put you on community control sanctions for a period of 2 years. You need some serious help, though, however, in regards to addressing your way of thinking.
Yeah.
And I'm going to provide that help. I'm going to order that you serve 100 days in jail. You have credit for 41 you've served. I'm going to order that as soon as a bed is available at NeoCap, that you be released from the Lake County Jail. You enter the program at NeoCap and you complete that successfully, following all their aftercare recommendations. As soon as a bed's available, you can go there. Any balance of jail time will be vacated. Upon completion of NeoCap, I'm going to order at this time, you most likely aren't going to have to do this, but to return to the jail for 30 days for the Transitional Day Reporting Program. That is just a program that helps people make the transition from being locked up to being on their own. Many people, when they've been in custody for a while, have nowhere to go when they get out. But if you have housing set up, you have work set up, and you don't need that assistance, I'll vacate those days. You won't have to do them.
Yeah.
But it's a good program for those people that need that, so I put it in place for everybody.
I'll take it, and I do pay rent.
You've told me that multiple times. I know you pay rent. So assuming that that's all set, then that's not going to be an issue. Further conditions are going to be that you're not to use any drugs or alcohol. That includes no marijuana and nothing. You're to submit random urine screens. When requested, they have to be negative. A positive screen's a violation. If you screw around with a urine sample, bring in fake urine, someone else's urine, do anything, that'll be a violation. That's worse than testing positive. I'm going to order that you attend AA meetings as recommended by NeoCap. So if they don't recommend any, you won't have to do any. If they recommend AA meetings, you have to do them per their recommendation. Further conditions, you're to obtain and maintain full-time employment. You are not to possess any firearms. If you have a firearm, you're going to go to prison. You're going to get new charges also, but you're going to go to prison. You are not to drive a vehicle without a valid license. So I'm not suspending your license, but a condition of your probation is that you're not to drive a motor vehicle without a valid license. So if you get your license, or valid privileges. If you get privileges from whoever has your license, suspended your license, if you get valid driving license, you can drive. But if you don't have a valid license or valid privileges and you're driving a car, you're going to go to prison. It's not going to be 3 days in jail or you know, like that you're saying you're used to. If you get caught driving a car and they don't even charge you, I don't care if they don't charge you, but if you're driving the car and that can be proven that you're driving the car, you're going to go to prison by me. You understand that?
Yes, I do.
You prepare court costs and supervision fees. Order the forfeiture of the contraband and instrumentality set forth in the specification. Ms. Henley, anything else that I'm missing or that should think about?
Just the standard, one doctor, one dentist.
I don't think that's necessary here. Thank you, though. I appreciate that.
Yep.
Mr. Lewis, you understand all the conditions of your probation?
Yes.
Any questions for me?
No, I'm not getting released today.
I'm sorry?
I said I heard of a guy named Damian Gladden. He went to NeoCap and they said he had to wait for a bed or something.
Yeah.
I just want to understand like the stipulation.
You need to wait for a bed, and then once the bed's available, you'll be released from the jail and go right to NeoCap.
Okay, so just let my family know I'm not coming home soon. And how long would NeoCap?
I don't know. You're not going to be coming home soon.
Yeah, how long is
NeoCap's anywhere from 3 to 5, 6 months.
Okay.
It depends on the issues they have to address, and it depends on how well you do. If you go there and you put forth the effort and you focus and pay attention, it'll probably be shorter. I don't control that.
Yeah.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime while you're on probation, a motion to terminate or end your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, including jail time, or I could terminate or end your probation and send you to prison at that point. And if I sent you to prison for violating your probation, it would be for 18 months. So that's what's hanging over your head, 18 months in prison. You understand that?
Yeah.
And that would be consecutive to any other prison sentence you may be serving for some other case, or that you're being sentenced to at that time for some other case. You understand that?
Yeah.
All right. Ms. Bell, anything else?
Nothing further, Your Honor. Thank you.
Mr. Matthews?
No, Your Honor. Thank you.
on the field.
Ohio versus Cody Fields, case number 26 CR 263. The defendant is present in open court with her attorney, Mr. Mulkey. We were last before you on April 20th of this year. At that time, the defendant did enter a plea of guilty to possession of cocaine, a felony of the 5th degree, with the attached forfeiture specification. Your Honor ordered a pre-sentence report and a drug and alcohol evaluation. Both have been completed, and we are here today for the purposes of sentencing.
Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Judge, thank you. She is 38 years old. She has struggled with substance abuse issues for her entire life. I believe most of her criminal history, if not all of it, stems from her addiction. I know she's been to New Beginnings before. She'd be interested in going to New Beginnings. Again, wants to do residential treatment. I think I saw there was a dual, she needs dual diagnosis for mental as well as substance abuse. She's currently on Buspar, mental health medication, I think, for anxiety. Other than that, Judge, I know she wants to get her GED, and at some point, it'd be nice if she could kick the drug habit, get back into society, and maintain some sort of stable employment. But she does want to get treatment. She'd like not to go to prison. If there's a way to avoid that. She's been once. She indicated that really didn't do her any good. Well,
there's a way to avoid it, but I'm told that she doesn't want to avoid it.
Right, yeah, and I discussed that with her briefly before Your Honor took the bench about NeoCap versus prison time. Now, sometimes in my experience that when we're actually out in front of the court before the judge, sometimes a person reconsiders and has a change of heart in that matter. I don't know if Cody would do that, because I certainly wouldn't want to set her up for failure. But I did discuss that NeoCap or prison, and she relayed to me that prison would be the option, at least the last time that I spoke to her.
Well, then she doesn't want to avoid prison if at all possible.
No.
That's not an accurate statement.
Well, she wants to. She wants to avoid NeoCap and prison. I guess that might be more accurate. But she doesn't get to choose what her sentence is going to be. So beyond that, Judge, I would defer to the court for the purposes and principles of sentencing, and Cody may want to address the court as well. Judge, thank you.
Ms. Field, you have the right to address this court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Trusting up.
Whatever you want to do.
Yeah, I mean, I'm embarrassed even being back here so soon. I don't know. The only reason why I'm saying NeoCap is around large crowds. I just don't want to get kicked out of there, and I just want to get comfortable where I'm.
Why would you get kicked out of there?
Because my anxiety is so bad around people. There's no way I'd be able to sit from morning till night during classes. I mean, I'm not trying to make up any excuses. It's just my ADHD, my anxiety, everything. It's just, I don't know. I've just heard horror stories, and I don't see how I'm even going to be able to sit still for that long. And that's not me just being trying to just make excuses.
So, I'm not going to send you to New Beginnings. That didn't work last time.
I completed it.
Completed it, and you came back and you had to go to prison because you couldn't comply with probation.
Yeah.
So, are you telling me that I'm willing to put you on probation and have you go to NeoCap and complete that program, but you're not going to dictate how this is going to work.
Yeah.
You need some significant help, which NeilCap can provide. What do you do every day? Like, you wake up in the morning. Tell me what your day entails.
Not much at all. It's been just revolved around drugs my whole life.
So you just wake up and start using drugs?
Sometimes. I don't know.
How old are you now?
38,
So how long have you been doing this?
like 20 years.
So for 20 years, you just wake up in the morning and don't do anything.
I mean, no, I do stuff in between, hang out with friends, whatever. I mean, I've had jobs in the past and all that, but whenever I'm using, I'm not very functional.
I mean, you told probation you haven't worked in, quote, years.
Yeah, like 5, 6 years. It's been quite a while. I've been in and out of jail and prison. I mean, it's been quite a while. Yeah, you can't get a job whenever you get a warrant.
Put yourself in any treatment programs while you've been out? You don't need to commit crimes to be ordered to go.
Yeah, I was in IOP from whenever I got out of prison up until I got arrested.
Well, you obviously then need more help,
Yeah,
but you don't want it.
I do want it, Your Honor. NeilCap, I don't know. I want to been cuffed out, or you know. My anxiety is that bad. I can't sit in a chair for hours on end.
Is there anything else you want to say?
That's it, I guess.
Schmolke, anything else?
No, Your Honor, thank you.
Ms. Contour?
Thank you, Your Honor. At this time, the state is recommending prison. The defendant does have 2 prior felony convictions. One resulted in a prison number. She was on probation with the Painesville Municipal Court at the time of this offense. She is currently serving a sentence for that case, and she's had at least 5 jail reports from the time that she was arrested until now, which show she cannot comport herself in the jail, let alone on community control. So we do feel like prison is appropriate at this time.
This court has reviewed the pre-sentence report and investigation. Drug and alcohol evaluation. Consider the facts and circumstances of the offense involved, the nature of the offense. I've considered what's been said here in court today. All this is considered only the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912, the court will note the defendant was operating a vehicle at the time she committed this offense, passed out at the wheel. It makes it more serious. Nothing makes it less serious. As for recidivism factors, court finds the defendant was on probation at the Painesville Municipal Court at the time she committed this offense. She has a history of criminal convictions. She has not responded favorably in the past to previously imposed sanctions. She's been on probation to this court before, violated her probation, was ultimately sent to prison. She has served a prison term. It's a drug abuse problem that relates to the offense, and she recognizes it, but she doesn't want the help that's we're willing to give her. She'd rather go to prison. These are all factors indicating recidivism is not just more likely, but almost guaranteed. I mean, you're going to be back here if you don't get help. No question about it. And then we're just going to go. It's this cycle that you're going to have. You're going to come to prison. You're going to come here. You can go to prison. You're going to get out. You're either going to overdose and die, or you're going to get arrested and come back to court and go to prison for longer, get out. And it's just going to be that cycle. And if that's what you want, I'm not going to argue with you. You've done new beginnings before. You violated your probation and went to prison. NeoCap helps with so much more. Just helps you with your thinking and your just life skills. You don't do anything. You wake up and just exist. You don't work. You don't do anything productive. But apparently that's the lifestyle you want to keep going with. No factors indicate recidivism is less likely. Under 2913B1, defendant previously served a prison term. Under the circumstances here and with her attitude, prison is consistent with the purposes and principles of sentencing, and she's not amenable to community control sanctions, available community control sanctions. Therefore, it's the sentence of this court. Defendant served a term in prison of 11 months. She doesn't have any credit because she's been serving municipal sentence this whole time, and that credit all goes towards that. Need to advise you upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can return you to prison as punishment for violating their rules for another 5.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, and transfer to transitional control. Defendant's ordered to pay all costs and will forfeit the contraband and instrumentality set forth in the specification. Contour, anything else for the record?
Nothing further, Your Honor.
Mr. Mulkey.
No, Your Honor, thank you.
Your Honor, we're hearing case caption State of Ohio versus Christian McLean, case number 25 CR 00198. We are here today for purposes of sentencing with Charles Langmack, who's representing the defendant, following a jury trial in which the defendant was found guilty of count 1, failure to comply with order signal of a police officer, felony of the 4th degree. Felony of the 3rd degree, wasn't it?
Third degree.
Felony of the 3rd degree. In violation of 2921.331B of the revised code, with additional finding that he was operating the vehicle and that it causes substantial risk of serious physical harm to persons or property. Count 2, obstructing official business, a felony of the 5th degree in violation of 2921.31 of the revised code, with the additional finding that the defendant's conduct created a risk of physical harm to any person. Count 3, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, misdemeanor of the 1st degree, and then in operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, the refusal also being misdemeanor of the 1st degree. Case was then referred for a pre-sentence report and investigation and a drug and alcohol evaluation. As I indicated, we're here today for purposes of sentencing.
Before I go to Mr. Langmack, the state needs to elect between counts 3 and 4. Which count does it would like to proceed on?
Count 4, you're under the refusal.
Okay, so count 3 will merge with count 4, so the defendant will be sentenced, then counts 1, 2, and 4 then. 1 second. Mr. Langmack, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Thank you. Initially, it is my understanding that Mr. McLean does intend to appeal the finding of the jury verdict. With that, I will obviously keep things relatively short, but surely we are here for sentencing today, Your Honor, and obvious choices are prison or probation. We would ask, Your Honor, that you grant community control, also known as probation, to Mr. McLean. As I said, he intends to appeal this finding, so obviously he is not going to speak to this for that reason. I know he does have family here, and I believe some of them wish to speak on this as well, or on this, in lieu of him. Your Honor, Mr. McLean is currently in mental health treatment. He's at Strive, I believe he's...
Correct.
At Strive. He's currently seeking treatment on his own. He was doing that before this. He intends to be doing this after this, regardless of what the court decision is. Mr. McLean's goal is to make his life better. And it did not and will not need a court order for him to do that. He's going to do that on his own, as he has been doing. He is addressing it. We're asking, Your Honor, to allow him to continue to work with Strive. We're asking that he be released today. He has currently served 100 days. I believe this last stay was 96 days, then he had 4 days before that, totaling 100 days of credit. He would like to get out, he would like to go back to work, he would like to restart all his work that he's been doing with Strive and move forward, become a productive member, try to get a handle on what's going on in his life all around, and that's basically the gist of it, Your Honor. We're asking that you take that into consideration, as well as the fact that he does intend to appeal, so that maybe any sentence might be stayed pending his appeal. Thank you. And I do believe it. I don't know how many people want to talk, but if anyone wants to talk, if Your Honor would grant his family the opportunity.
If you're okay with it, I don't do it unless you want me to. I don't just let people come in and talk if they're not being, if the defense doesn't want them to.
No, he is all right with that, Your Honor.
Well, if there's anyone here that would like to speak on behalf of the defendant, you can do that now. I did receive multiple letters. I don't know if they're from the folks here or from others also. and I've read all those, but if you want to say anything here in court, you can do that at this time. Obviously, one at a time here, but anybody? All right, sir, you can just stand right where it is that you're seated. State your full name and spell your last name for our court reporter, then take your time and say whatever you want me to know.
Okay. First name Kendall, Kendall. Last name Durham, Durham.
Okay, take your time and just say whatever you want me to know.
Your Honor, I'd just like to say that I met Chris over maybe about 15 years ago. He was dating my daughter here. And I keep thinking about that first day that I met him. He came to a family function, and his hair was in braids, and he was looking big, wild side. You know, as a father, you want the best for your daughter. And I'm looking at this guy, you know, like they say, you can't judge a book by its cover, but I was like, oh God, here we go. And, you know, after a while, I began to be around Chris, and I was like, I don't know about this guy. I kept saying that to myself. 1 year went by, another year went by, and I kept saying, I don't, you know, because for a father, you want the best for your daughter. So one day I took him to work with me. I seen he's a pretty good worker, sing to listen, whatnot. But as talking to him, I could tell that he was a troubled kid, and he had a lot of trauma in his life. And I had specialized in that with through my family. We do construction. We have inner city houses. We work through the urban development program, doing rehabs on seniors' homes and stuff like that. And you know, I was like, I need to take this guy under my wings. He seemed like, you know, he's not such a knucklehead or whatever. And we had developed a relationship. And I've just, over the years, I watched him mature as a young man, where he started calling me dad, and I called him son. And I'm just thinking that, wow, this is a big change from how I originally felt about it. And, you know, I just want to do a character witness thing here. Like, give you an example, last year. I worked for the Department of Aging. I cut seniors' yard. And we started May 1st every year. Last year, I cut yards for like 60 days, and then they'll pay another 60 days, normally after you pay. How about they didn't pay for 90 days? Now, I'm running a small mom-to-pop operation. I need my money because of, you know, the gas and whatnot, like that. So my help quit on me after 60 days because I told them, look, when I get a check, y'all can get paid. They're like, hey man, you know how it is. We gotta have our money, whatever. I said, okay. So I'm gonna get Chris. I explained to Chris, I said, Chris, look, they have not paid me. They keep saying they're gonna pay me. He said, don't worry about it, I got you. So he came to work with me, he started working with me. And the thing was, that really made me feel real good about Chris is that when you're out there working in the field, you'll have people that say, hey, can you all come cut my yard or whatever. So we would get this little extra money just to keep going, and we would cut these yards and say they may pay like $50. And I would always split the money. I'd say, hey, Chris, here's some. And he would say, no, keep the money. He'd say, how are we gonna come to work tomorrow? How are we gonna cut other people's yard if you don't have gas to put in the truck and put in the equipment? Don't worry about it. Just, you know, don't worry about it. We would go, seniors would ask for bushes to be cut, whatever. That was not in our contract. Chris would always do the extra stuff they would ask them to do. Like this year, I already got started without him. And all the seniors like, where's Chris at? I didn't want to tell him that he was, you know, being held or whatnot. I just said, you're on vacation, you're on vacation. It's like, where's this, hey, where's my guy at? I say, hopefully he'll be here shortly. He's on vacation or whatnot. And I just want to say that every year, holiday time, 4th of July, he's the guy in the neighborhood to buy all the fireworks for the kids. You know, he's a patriot. He loves this country. He loves what it stands for. And he just go all out on the 4th. And I'll be like, Chris, why are you spending so much money on fireworks? Dude. But he said, hey man, I love this country. He said, I always wanted to serve in the service. And I was like, why do you serve in the service? He said, because guys in the neighborhood, we don't serve in the service. You know, they think it's corny. I say, you should be here. He said, man, I always wish I would have joined the service. I would be some. I'm like, it ain't too late. You can do this. If that's what you really want to do. That was one of the things that we wanted to do that we never did. Christmas time, I almost want to say the biggest fool I ever seen. Christmas tree 6 feet tall, gifts under the tree, 4 feet high, buying gifts for everybody. Chris, why? I love these holidays. Like he has kids. His kids, man, his kids need him. They miss their father. They need him. We need him. You know, it's just, I'm not going to make any excuses for what he did. But what I will say, Your Honor, is that I don't even know if this is the right system for him. He has issues that need to be dealt with. And when I sat there and I watched that film and I seen that he was asking for his mother, I knew that there was something going on with him. That's why he was asking for his mother. And it's just sometimes when you're looking at how, in this day and times, the mental illness sometimes that police officers aren't properly sometimes trained for that, you know, and it's new to them, because I know we got a lot of people with a lot of issues now. And that when I seen him doing that, I was just thinking, I wish the officer would have just took the phone for a second. He probably could have de-escalated, but not saying anything that he did, because what he did, he did. The officer clearly, when I seen the film, said, hey, if you take off, it's going to be some problems here. And I know he took off, but what I'm trying to say is I know in his heart, because I've been dealing with him for weeks and weeks and years before, and he had just been getting himself together, that if he had it to do all over again, he really would. And I know that he's sorry, and I know that he's remorse, and he just needs that second chance. And I wish you could find it in your heart today, just to please give him a second chance at it. I'm pretty sure he will go astray, because he's been astray for a while. If you look at his priors or whatever's there and see how long it's been since he's actually been in any type of trouble. And that's all I really want to say, that his family needs him, his kids need him, his community needs him, and he's not doing anybody any justice sitting in a jail, in a cell, you know, just right. But I understand you got to do something, because that's your job. Thank you, Your Honor.
Thank you, sir.
I appreciate your time.
Thank you. Is there anyone else? Okay.
My name is Grisham
You have
McClain.
to speak up a little bit.
My name is Grisham McClain. I'm his daughter.
Grisham McLean. How do you spell your first name?
CHRSTIAN.
One more time, I'm sorry.
CHRISTIAN. I recently just went to graduation and having to take the smile, knowing that my dad would be able to see me present. Having to act like I'm okay, walking across the stage, knowing my dad isn't there. And not having a present, it just a huge impact on me. And having to go through everyday life, not knowing that he's in jail, having to speak to him for a video call, for him to see me, and then the call not being able to show my face, and I didn't get close and stuff. It just, I just miss my dad, man.
Thank you. Is there anyone else? Ma'am?
It's okay if I talk my phone.
Sure. Just keep your voice up, though, please.
Okay. My name is Kendra Durham, Kendra. I have.
What was the last name?
Durham, Durham.
Thank you.
I have 2 kids, one with Christian. I just wanted to say that him being in jail is a great hardship for my household. So I am a single mother that works from 6 a.m. to 6 p.m. And a lot of the times I don't have transportation, for my children to get to and from their after-school activities events, their extracurricular sports events, and things like that. And he's the person that takes care of that with both my children. He also helps financially with him not being able to be there to help with other things. So I'm now having to take hours off of work or miss days at work, which is affecting me being able to keep up with rent, utilities, bills, my kids' extracurricular activities and things like that. Just like they stated, the children miss them. It's affecting them emotionally, and it's putting this all on me because I have to be strong still while I'm still dealing with all the extra weight that I'm picking up by him not being there. That's all I wanted to say.
Thank you. Anyone else? Mr. McLean, you have the right to address this court. I'm sorry. I didn't see.
Hello, my name is Brenda McLean. I'm Christian Law.
Okay.
I just want to say, I had 10 kids. I had 10 kids. He's the last, the 10th one. And I had lost one was killed. Another one dropped dead. Had worked at Amazon 2 years ago. And another one that had some issues, killed himself. Last year in July, I had just got home from work. And I was having some issues with myself, and I was feeling bad. And my daughter, I called her, and I was having a stroke. So she called Christian, who got there so quick, carried me downstairs, but I couldn't walk, got me to the hospital. They gave this medicine I have to take within some time so I can be able to do that. He got me to the hospital. He's been coming around to help me. I'm living in a hospital by myself. He comes around to make sure, if I can't do everything, I still have paralysis and everything. I can't do so much, and he comes to make sure I'm taking care of, make sure everything's done. And I really need him because he's there for me. And I just want to say, I know he was calling for his mom because I'm here, that's who he was and everything. And I was trying to help him and everything, and I love him so much that I want to say, please, show some mercy for him. I really need him, his kids need him, we all need him, and like I said, that's all I just wanted to say. Thank you.
Thank you.
You can read my letter.
I did do that. Anyone else? Yeah.
My name is Sharia McLean. That's SHARRIA MCCLAIN. I'm Christian's sister. Number 8 out of 10. And without his presence being there, like it's really tough. It's like every year, like I just celebrated a birthday, and it's like every year I'm not celebrating with another sibling, father, somebody. Like it's just been a tough time. It's like growing up and getting older. But with him being present there, he always makes sure everything is kept together. Like he's the youngest, but you would never know that because he acts like everybody's father, so to say. Like he's present with everything, and not to mention he's a great father, not just to his children, but to my children also. Because I'm a single parent myself, but he helps out there. And just a little story of his character, of who he is. Like when I work in a community where I take care of the elderly, and I've been doing that for over 10 plus years. And my client passed away, and like I really developed a bond with her, and he just told me like it's okay. So like without her being there, like that took a toll on me itself. But he was just like, don't worry about paying your bills. I got you. Like I understand, like you're a mother still. And he like, you will find something else or whatever to get into, but he's just always there. if it ain't for me, it's for my children, for his children, for everybody. And it's just like for a person to be so young, but he spread so thin where he managed to make time to give back to everybody. And no, he's not like a perfect person, but he's definitely has matured and grown through the years to the point where I definitely noticed the growth of him being like a real staple to just the household, the families, everybody that he contributes to. Like, it's definitely a change from his younger years to growth as a man, as a father, as everything. So a son, all the different hats that he holds, uncle, just everything to everybody. Like, he's really a great person to the point where I can't even express or put into words to say like how wonderful he is. Like, he's a headache as a brother, but that's my headache. You know what I'm saying? I love him to pieces or whatever, and that's little big brother. And it's just like I'm down from 6 brothers to 4 brothers, but he still makes sure, like, he can't replace that other type of love, but he dang sure do a good job of like being present and helping everybody out. Like, I couldn't even put into words of really how great he really is. But he's really a wonderful person.
Thank you.
Thank you.
So, Mr. McLean, you have the right to address this court before you are sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes.
Okay, go ahead.
Well, I just want to say that I'm very apologetic for everything that happened, and
He's not going to hold it against you if you don't want to talk about it. It doesn't hurt me. But if you want to say something, you're allowed to.
and I just ask this court to give me a second chance and give me a chance to really work on myself.
I understand, as your lawyer said, that you went to trial, you're planning on appealing this, so if you think it's in your best interest not to say anything or not to go into anything, that doesn't get held against you, so I don't want you to be concerned with that. But you do have a right to speak, and I got to make sure I afford you that opportunity, so if you want to, you can, and if there's anything else you want to say, you can. But you don't have to.
Okay. I just asked this court to give me a chance to make things right.
Okay. All right. Thank you. Mr. Mack, anything else on behalf of the defense?
Nothing else, John. Thank you.
For the state of Ohio, Ms. Linden?
Thank you, Your Honor. Your Honor, as we discussed in chambers, he does have 100 days of credit for time served, and I appreciate everything that his family has said, and certainly I'm sure that that's all true. The problem that we have is the defendant's lack of insight and his lack of responsibility really for what happened here. He sees this as a misunderstanding, a mistake, an incident, but not an offense. He denies drinking. When the officer came up, smelled alcohol, bloodshot eyes, slow movements, you were able to listen to his discussion with the officer. Rather than just answering the questions, he was kind of a smart aleck and just reiterated those questions back. So he says in his pre-sentence report that he feared for his life, but he started out, and you saw the officers, they were nothing but kind in talking to him. It was the defendant who escalated the situation and escalated the situation. They gave him chance after chance after chance, not just one officer, but another officer. They were so patient with him. I've never honestly seen officers be that patient about trying to get a defendant out of the car. His lack of compliance is what necessitated there to be more and more officers. And at one point in time on that, you hear him say, oh, you just go ahead and kill me. And they're all like, wait, that's not why we're here. That's not what this is about. So the misunderstanding may be on his part, but he had been drinking, he was eating, he was committing a traffic infraction, he was pulled over, and he failed to comply with those orders. And then he ends up putting a number of police officers at risk as well. I mean, they're standing right by the car, the terminator stick is there, and not only just the officers, but then when he takes off, where he takes off is right by that exit, where there are a number of people going off and on, there's a semi there, and he doesn't stop on his own accord. It's only because everything finally gives out after the second set of stop sticks. So with all of that, this is something that he created. It's not a matter of the police creating this for him because they were very patient. This is over 10 miles. He goes over 100 miles an hour, and again, he's slowing only because of those stop sticks. They had to close down the roadway. We had Ohio State Highway Patrol, Mentor Police Department, Willoughby Police Department, Wickliffe Police Department, and Willoughby Hills Police Department, all involved in this. And then looking at the defendant's history, he has over 40 traffic infractions, including a prior OVI. He has a history of juvenile and criminal convictions going back to 2006. I will acknowledge that between 2020 and 2025, it does appear that he led a law-abiding life. I don't see any infractions really during that period of time. He did have multiple scram violations and multiple opportunities to turn himself in, but chose not to do that. So I would just submit all that evidence to the court, leave the decision obviously to the court's discretion with the appropriate driver's license suspensions and the credit for the time.
Thank you.
Thank you.
This court has reviewed the pre-sentence report investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offenses involved and nature of the offenses. Obviously, I presided over the trial and got to hear all the evidence that was involved in this case, and I've taken all that into consideration. I have also received and read numerous letters that have been submitted to the court in support of the defendant. I've read all of those and considered those. I've also considered everything that's been said here in court today by the defendant's family members, his lawyer, the defendant himself, and I've also considered what the prosecutors had to say. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12 that indicate the offense is more or less serious, the court is also directed to consider the factors set forth in 29-21.331 for a fleeing and eluding charge. And those deal with the manner of driving and the circumstances surrounding the fleeing itself. And in this case, the court notes the defendant at one point went over 100 miles an hour, that this chase and flight was over 10 miles. These are both factors that make it more serious than the normal fleeing and eluding. The road had to be blocked. The freeway had to be closed down in order to protect people in the community. There were 6 police departments involved in this chase. All these are factors indicating it's more serious than the normal fleeing and eluding charge. The defendant did create and cause a risk of serious physical harm to persons, not just property, but persons in committing this offense. It is considered, therefore, an offense of violence. Just when he left itself, put the officers at risk of physical harm, serious physical harm. Nothing makes it less serious than normal. As for recidivism factors, the court notes the defendant does have a history of criminal convictions that goes back 20 years. Now he's got no prior felony convictions. This is his first felony conviction. He has been on probation before in the past and has violated his probation, so he's failed in the past to comply with previously imposed sanctions ordered by courts. I don't think he truly appreciates the seriousness of his conduct. He talks about in his pre-sentence report that he didn't commit a criminal offense. It was just an incident. I'm not really sure what he means by that. But you did commit a crime. You committed a criminal offense. This was not a mistake, like you referenced it. It was a deliberate, intentional act that you chose to engage in. Court further finds you violated the conditions of your bond. Violating the scram conditions, those are factors indicating recidivism is more likely. Going back to your criminal history, I usually don't reference traffic stuff too much, but you've got a lengthy driving record, which includes 2 prior DUIs, one within the past 10 years. Your license has been suspended 25 times for different incidents. There's no factors indicating recidivism is less likely. This is a felony of the 3rd degree, so there's no presumptions one way or the other for prison or probation. Prison is certainly consistent with the purposes and principles of sentencing, with the nature of this offense and the conduct involved, and I could certainly justify a prison term here based on the conduct and based on your lack of accepting responsibility for what happened here. But I will find at this point that you're amenable to an available community control sanction, and I'm going to give you one chance on community control sanctions. Now, you're not getting out today. You're going to get some help, and we're going to give you some help before I put you out on your own, but I'm not going to send you to prison today. I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 160 days in jail. You have credit for 100 you've already served. I'm going to order that as soon as a bed becomes available at NeoCap, that you be released from the Lake County Jail and you enter and successfully complete the treatment program at NeoCap. Any balance of jail time will be vacated. You're to successfully participate in that program and successfully complete it, follow all their aftercare recommendations. Upon completion of the NeoCap, I'm going to order, and you're probably not going to have to do this, but I am going to order that you return to jail for 30 days for the transitional day reporting program. Again, you most likely won't have to do that. But that's a program that helps people make the transition from being locked up and in custody to being on their own. Some people who are locked up for a little bit have nowhere to go when they get out. They don't have any housing set up. They don't have any work set up. If you've got that all lined up, and it sounds like you probably will, then your probation officer will let me know that, and I'll vacate those 30 days. You won't have to do that. But it's a good program to have in place for people that do need that help, so I put it in place for everybody. At that point, the further conditions are going to be that you're not to use any drugs or alcohol. You can't drink. You can't use any drugs. You have to submit random urine screens. They have to be negative. A positive screen's a violation. You can't screw around or tamper with any urine screens. That's a violation. I'm going to order that you attend AA meetings pursuant to whatever the recommendations are from NeoCap. So if they recommend that you don't have to do any AA meetings, then you don't have to do any. If they recommend you do 3 a week, you have to do 3 a week. Whatever their recommendations are will be a condition of your probation. Further conditions, you're to obtain and maintain full-time employment. You're to continue mental health counseling with Strive Mental Health and Wellness. Get individual counseling from them. Continue your mental health medications with them. I'm going to order, well, first of all, I have to suspend your driver's license for these offenses. It's mandatory. Count 1, your license will be suspended. The minimum is 3 years. I'll suspend it for 3 years. Count 4, I'll suspend it for 3 years as well, but that'll be concurrent suspension. A condition of your probation, however, is going to be that you are not to drive a vehicle without valid license. So I'm adding that in there because if you drive a car and you're not charged with driving under suspension or convicted of driving under suspension, you're still violating your probation because you're not to drive a motor vehicle without valid license. The suspension is not a condition of your probation. It's just saying that you basically have to honor that suspension. And if you don't get caught or get arrested, but someone sees you driving, you're in violation of your probation, and you're going to go to prison. So if you drive a car, you're going to prison. You understand that?
Yes, can I ask a question? With that suspension, like, is there any way to have like any privileges?
No.
Probably no.
The law doesn't allow me to. It's not even that I wouldn't be able to. With fleeing and eluding, you're not entitled to privileges for the first 3 years of the suspension. Now, if I gave you more than a 3-year suspension, you'd be able to have privileges after that. I'm not giving you more than the minimum's 3, and that's what I'm giving you, but you're not allowed to have, I'm not allowed to give you privileges.
Understood.
You to pay your court costs and supervision fees. There's a mandatory fine for the OVI in count 4 of a minimum of $715, and that's what I will order. The 2 years of community controls for each count concurrent. You only have one doctor and one dentist that can prescribe you medication. If you have a specialist, that's fine as well. But probation needs to know who the doctors are that give you prescriptions. You can only get them from those doctors. You can only get them filled at one pharmacy. They need to know where that is as well. And you need to sign whatever releases they need so they can talk to the folks if necessary. Take all your medications as prescribed. Mr. Randallson, is there anything else I should be considering here?
No, Your Honor.
So, Mr. McLean, you understand all the conditions of your community control sanctions?
Yes, sir.
Do you have any questions for me?
Okay, so last question is, so I will be submitting urine samples as opposed to having a unit, because last time that
So
unit,
as opposed to what?
having a scram unit.
You're not going to have the scram unit anymore.
I did provide lab results because those scram units, I never violated probation, period.
No, we're not going to argue about that at this point.
Okay.
That was bond condition. You're not being required to wear that for probation. You'll be required to submit random urine screens or whatever testing they request. If they request a breath test, you have to do that as well.
No problem.
Whenever they request that. Do you have any other questions regarding your conditions of probation?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it'd be a period of 60 months or 5 years on count 1, an additional 12 months on count 2 to be served consecutive. So 6 years in prison is what's hanging over your head. You understand that?
Yes, sir.
And that would be consecutive to any other sentence you may be serving at that time for something else, or that you're being sentenced to at that time. Court further wants to note for the record, I alluded to this earlier, since I imposed community control, post-release control is not an issue at this point, but I am making the finding that this is an offense of violence, so that if we ever have to do post-release control, if the defendant goes to prison for violating community control, it'll be mandatory PRC. The last thing I need to do, Mr. McLean, is that I need to advise you of your right to appeal. I know there's been some talk about that, but you do have the right, in this case, to appeal the convictions in this case. Specifically, if you are unable to pay for the cost of an appeal, you have the right to appeal without payment. If you are unable to obtain an attorney for an appeal, counsel will be appointed for you without cost to perfect your appeal. If you are unable to pay for the cost for the documents necessary for an appeal, which includes a transcript of all proceedings that occurred when we were here in court, you will be provided that transcript and those documents without cost to you. And you have the right to have a notice of appeal timely filed on your behalf. Now, your lawyer mentioned that it is your intention to appeal the convictions. Mr. Langback, are you going to be representing him in that, or does he need a lawyer appointed, or will there be another lawyer retained?
We would need one appointed, Your Honor.
Okay. Well, the court will appoint a lawyer then to assist you with your appeal. That will get done within the next few days.
Thank you.
Is there anything else for the record at this time, Ms. Linden?
And I know this probably goes without saying, but in terms of the no drugs or alcohol, that includes marijuana?
Yes,
even medical
no marijuana. That's not permitted.
And the date of the suspension, does that date back to the date
Starts
of the
today.
offense as of today? Thank you. Nothing further.
Mr. Langback, anything else?
Anything else, Your Honor?
All rise.
This afternoon in the state of Ohio versus Jeffrey Halsell, case number 26 CR 285. Defendant is present in open court with his attorney, Mr. Watson. We were last before you on April 20th of this year. At that time, the defendant did enter a plea of guilty to possession of cocaine, a felony of the 5th degree with the attached forfeiture specification. Your Honor ordered a pre-sentence report and a drug and alcohol evaluation, both of which have been completed. We are here today for the purposes of sentencing.
Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. I know the court is well aware of Mr. Halsell's record. It's admittedly quite extensive. Most recently, in his past, it has been a lot of misdemeanor thefts, and he usually gets caught with drug paraphernalia or drugs on him, which I believe is the basis of this case. Your Honor, I know Mr. Halsell's been in and out of prison his entire life. He's, I believe, 66 years old at this point. He's told me that he's tired of living this life like this. As you can tell, there's a nice young lady in our courtroom today. I mentioned her in chambers. If the court were to consider a community control sanction for Mr. Halsell, first, we do have him on the wait list at Lake Geauga Recovery Center, so there is eventually a bed going to be available there. And then, at some point, as long as he's successful, he has stable housing. The house is located in Lyndhurst, Ohio. So he has at least a place to go. I'm asking the court, even though his record is bad, I'm asking the court to consider a community control sanction with whatever restrictions the court deems appropriate. Put him on a short leash, give him one opportunity, and if he doesn't follow through, then he knows where he's going to go, Your Honor. Thank you.
Thank you. Mr. Halsell, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, sir. I'd just like to say that I'm trying to do the best I can. I just want to get my life in order. I just want to try to do the right thing. 66 years old, and I'm tired. That's all I can say, so.
Thank you. Mr. Watson, anything else on behalf of the defense?
Nothing further, Your Honor.
Ms. Contour for the state of Ohio.
Thank you, Your Honor. The defendant is 66 years old, and his record dates back approximately 50 years, Your Honor. I counted approximately 10 to 11 prison numbers. There was burglaries, aggravated robberies, an extensive amount of thefts, F1s and F2s. So, Your Honor, at this time, the state does not feel that the defendant is amenable to community control sanctions and feels that prison is an appropriate recommendation.
The court has reviewed and considered the pre-sentence report and investigation. Drug and alcohol evaluation. I've considered the facts and circumstances of the underlying offense, the nature of that offense. I've considered what's been said here in court today by Mr. Watson, the defendant himself, the prosecutor, the recommendations. All of this is being considered by the court in light of the purposes and principles of felony sentencing set forth in 292911 of the revised code. So the factors in 292912, nothing's present indicating the offense is more or less serious than normal. As for the recidivism factors, almost all of these are present. The defendant has a very, very extensive criminal history, one of the longest I've ever seen. I've been doing this a long time. Dates back 50 years. 50 years. Incredible. He's been to prison at least 10 to 11 times here in Ohio. It's not counting any other states. And there's stuff out in California too, correct, Ms. Warren?
Yes, Your Honor.
If he has failed to comply with previously imposed sanctions ordered by courts, there's a drug abuse problem that relates to the offense. He hasn't done anything to address it all this time. No factors indicate recidivism is less likely. Under 2913B1, defendant previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's just no way this court can make the finding that the defendant's amenable to community control sanctions. It's just impossible with this history. Therefore, as a sentence to the court, defendant served a term in prison of 9 months. He has credit for 105 days he's already served. Need to advise you upon your release from prison, you may be put on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can send you back to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs, and I'm going to order the forfeiture of the contraband and instrumentalities. Ms. Contour, is there anything else for the record?
Nothing further, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
All rise.
Thank you, Your Honor. We are here in the matter of the State of Ohio versus Stephen Fisher, case number 26CR0000287. We are set today for a sentencing hearing. The defendant is present with his attorney, Mr. Fatika. We were last in court on April 20th of 2026, where the defendant pled and was found guilty to count 1 of the indictment, failure to comply with an order or signal of a police officer, a felony of the 3rd degree. At that time, a pre-sentence report was ordered. It has since been completed. The state's had the opportunity to review that and is prepared to move forward with sentencing today.
Thank you. Mr. Fatika, any reason not to go forward with sentencing?
Good afternoon, Your Honor. I don't believe there is.
Is there anything you'd like to say on behalf of your client?
Yes, Your Honor. I've had an opportunity to review the PSR. I'd like to highlight the fact that while acknowledging that Mr. Fisher has a significant criminal history, his most recent prison release was in October of 2020. Did have a traumatic childhood. He was in a situation with his mother, suffered abuse at the hands of his mother. Accepted responsibility in this case at the earliest time available to him. I wasn't available for the first pretrial, but we were able to get him in for a change of plea. We'd ask you to take the fact that he has accepted responsibility into fashioning a sentence here in this case. Also, I submitted a letter from his employer. He does have a job waiting for him.
Thank you. Mr. Fisher, you have the right to address the court before your sentence. You can say anything you like. Is there anything you want to say at this time?
Yes, sir. I own up to it. I was just nervous. Like, I had a lot going for me. I had a lot on my plate. That's it, Your Honor.
Anything else you'd like to say?
No, sir.
Sir?
I said no, sir.
Thank you. Mr. Fatika, anything else on behalf of the defense?
No, thank you, Your Honor.
Ms. Johnson for the State of Ohio.
Thank you, Your Honor. The state is asking that the court impose a prison term in this case. It's based in part due to the serious nature of this offense, as stated at the change of plea in the facts. This was a high-speed chase. The defendant at one point went up the wrong way of a one-way where there were construction barriers on either side. I spoke with the officer, who's now a detective. He said that at that point he terminated the pursuit based on the severe risk, and he said that he just held his breath for 10 seconds and hoped that no one came down, because it would have been a head-on fatal collision at that speed, and based on the fact that there would have been nowhere else for the other vehicle to go. The defendant also has a long and serious criminal history, which includes 7 times in prison. He did have an incident in jail, which was documented in the pre-sentence report. He's had multiple parole violations, and his history ultimately does date back to the late 90s. He currently has warrants out as well of Cuyahoga for multiple menacing cases. So for those reasons, the state is asking for a prison term. We also ask, as to the PRC, that this court does make a finding that there was a risk of serious physical harm to persons, and that did constitute an offense of violence.
Thank you.
Thank you.
This court has reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I've considered what's been said here in court today by Mr. Fatika on behalf of his client, the defendant himself. Prosecutor's comments, recommendation. I've received a couple letters on behalf of the defendant submitted by the Public Defender's Office. I've read those. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. So the factors in 2912, as well as 2921.331B, which are factors I'm required to consider in fleeing and eluding charges, the seriousness factors set forth there. Court finds the defendant committed multiple traffic violations. He did create a significant, substantial risk of serious physical harm to others with his conduct. He drove the wrong way, drove northbound and southbound lanes through a construction zone, which it turns out that it was only one lane because of the construction zone there. Normally a 2-lane, 4-lane road, but 2 each direction. But it was only one lane, and he went the wrong way, going northbound in the southbound lane, the construction zone. Created a significant, very significant, substantial risk of serious physical harm, of death, quite frankly, to others. That makes it more serious. Nothing makes it less serious. As for recidivism factors, defendant has an extensive criminal history, goes back over 30 years. He has served multiple prison terms, at least 7 different prison terms. One of them was a 15-year term. He's not responded favorably to previously imposed sanctions. He's got multiple parole violations. When he's been released from prison, he's put on parole or post-release control, and he's been sent back to prison because he hasn't been able to comply with the rules when he's out. No factors indicate recidivism is less likely. Felony of 3rd degree, no presumptions either way for prison or probation. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanction. Therefore, it will be the sentence of this court that on count 1, the defendant served a term in prison of 30 months. He has credit for 70 days he's already served. Need to advise you upon your release from prison, you can be placed on, court finds this to be an offense of violence based on the findings I made previously, and it did create a risk of serious physical harm to persons. Therefore, post-release control in this case is mandatory for at least 1 year, up to possibly 3 years. When you're on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term I imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. And suspend your driver's license for 4 years. It starts today. Dismiss count 2. Defendant's ordered to pay all costs incurred in this action. I think that covers everything. Ms. Johnson, is there anything I've omitted or I need to address?
No, Your Honor, thank you.
Mr. Fatika?
Your Honor, I just wanted to, my understanding from the PSR, we're not disputing the sentence. He did have prison terms in 7 cases, but I believe there were 3 numbers. You're calling it to my attention, I just wanted to.
Okay, thank you.
All rise.
We're present today in case 26CR376, the State of Ohio versus Tina Swope. The defendant is present, represented by counsel attorney John Fatika. We were last before the court on April 20th, 2026, when the defendant waived her right to indictment and pled guilty to a one-count information, that being aggravated possession of drugs, a felony 5, with a forfeiture specification. This case was referred for a pre-sentence report and drug and alcohol evaluation. Those reports have been completed. Both parties have had the opportunity to view those and are prepared to proceed with sentencing today. Thank you.
Thank you, Mr. Fatika. Any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes. Good afternoon, Your Honor. I've had an opportunity to review the pre-sentence investigation report as well as the drug and alcohol evaluation. I'd like to highlight the fact that in her 68 days at the Lake County Jail, Ms. Swope has had no incidents of any kind, except the responsibility by way of information. I'd like the court to be aware, and certainly what I saw as a turning point in the case, is the fact that when we were discussing the information, we talked about one of our options being, let's play our hand out. There might be a search issue here. Let's get full discovery and explore that possibility. Ms. Swope said no, she wanted to accept responsibility and pursue treatment here. We acknowledge that she does have some criminal history. She had a case in 16-17, successfully completed probation with this court back in 2024, but she has suffered some childhood trauma. She was her father died when she was shortly after her birth. She survived sexual assault as a teenager. She described her childhood as complicated. She does have some mental health diagnoses, which are outlined in the PSR. We respectfully request the court consider implementing the recommendations contained in the drug and alcohol evaluation. Consider her placing her at NORA. It's an extensive program, several months. We submitted a letter by Mr. Heller. He's here in the back of the courtroom to speak to the court as well.
He's here what?
He's here in the back of the courtroom. He'd like to be heard.
Well, do you want him to be heard?
Yeah, sure. And her mother is also here, and she'd like to be heard on Ms. Swope's behalf as well.
Well, we'll hear from whoever wants to speak at this point. You can just stand right where it is that you're seated, state your full name, and tell me whatever you'd like me to know. Whoever wants to go first.
Okay. Thank you for letting me speak. I just want to tell you a little bit about my daughter. She put herself through college on her own as a single mother. She ran an animal clinic for over 20 years. She was a veterinary technician, and she ran the clinic. Life happened. She got involved in the drugs. And the mental illness from something that happened in her childhood really bothered her. I just want you to know, I know what she is capable of. I saw she was summa Culotta, if I'm saying that right, in college, top of her class. She was diagnosed with a learning disability in school, but never had, but she did so well and fought through all that. I just know if you give her the opportunity, she could become that person again. I think the mental health is what really she needs someone to talk to. Thank you.
Thank you. Anyone else, sir?
Larry Heller with NORA. As you know, for many years, this honorable court has sent many of the most difficult clients to us at NORA. And as we know, National Institutes of Health and National Institute on Drug Abuse have created best practice standards and principles of effective treatment. One of the fundamental principles of effective treatment is that for many people, multiple attempts at treatment are required, and that we should never give up on anyone just because they may have been through treatment before. So, as I said, you've sent many people to us in the past, especially including people with multiple prior offenses, with multiple prior treatment episodes, and even people with multiple prior violations of community control. And many of these have thrived in our program and have done very well and not been back yet. So even those with multiple prior issues in the past seem to do well, but the point is to never give up on somebody just because they may have been through it a couple of times. We have many people who have required multiple episodes of treatment, but eventually have gotten it. I make no secret, I'm in recovery myself. I required multiple episodes, but today I'm doing pretty well, if I say so myself. And, you know, the evidence overwhelmingly supports that the most effective way to achieve long-term behavior change is through effective treatment rather than incarceration. Thank you.
Thank you. Ms. Swope, you have the right to address the court before you're sentenced. You can say anything you like. Is there anything you want to say at this time?
Should I stand up?
Whatever you're comfortable doing.
I understand that I have struggled since 2016. I completed OCAPS and it was amazing for what it had. It didn't have a mental health portion of it, and I think that's where I struggled afterwards. I came out of OCAPS, I did well, I was sober for a while. I got married. My husband started doing drugs, and I didn't have God in my life at that time. I kind of made him my higher power when he struggled. I fell, and I fell hard this time. You know, I think I was close to death, so sitting down this last 68 days has really done a lot for me, and not just in a punitive way, but I've also reflected. You know, they say it's a wreckage of your past for a reason, because I did. And I did a lot to my mom. But I have a different purpose now, so. I have a lot of tools from Oak House. I didn't know how to implement them correctly. I went back to old behaviors because it was what was easy. You know, I completed probation, but life gets you, and I know I didn't have the tools that I needed to, as far as leaning on a higher power that isn't another human who's fallible, to help me through it. So life recovery has made a big difference. Janelle Unger with Lake County Ministries, she's helped me a lot since I've been in there. I have a church that I'm going to go to when I get out. I have things implemented to change this time. I definitely don't want to live the life that I was living. So, thank you.
Thank you. Mr. Fatika, anything else on behalf of the defense?
No, thank you, Your Honor.
Ms. Tuttle for the state of Ohio.
Thank you, Your Honor. The defendant in this case doesn't have a particularly long history, but her history is all drug-related. She's had prior drug treatment with JTP and Oak House and is clearly still in need of some dual diagnosis treatment. The state believes that community control sanctions would be an appropriate sanction here, but would request that NeoCap be a specific sanction. The defendant has 68 days of jail time credit that she's already served.
Thank you. This court has reviewed the pre-sentence report and investigation, the drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved here, the nature of the offense. I have considered everything that's been said here today by all the parties that have spoken. I received a letter from the defendant. I've read that. I also received the letter that was referenced earlier from Mr. Heller, and I've read and considered that. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11, for the factors in 29-29-12. Nothing stands out factually indicating the conduct is more or less serious. As for recidivism factors, however, the court finds the defendant does have a history of criminal convictions. She has been on probation to this court before in the past. She did violate her probation when she was on probation to the court, but the court gave her a second chance and then she completed it. That was in February of '24. And a year and a half later, she started using again. No factors indicate recidivism is less likely. Under 2913B1, there's no factors present. At this time, prison would not be consistent with the purposes and principles of sentencing. The court will find defendants amenable to an available community control sanction. But previously, when you're on probation, I did JTP. I did residential here with Lake Jaga. And while you successfully completed probation ultimately, within a year and a half, you're relapsing, you're using daily until you got arrested here. So something more, if you're going to succeed, something more is necessary. I'm going to put you on community control sanctions for 2 years. I'm going to order that you serve 120 days in jail. You have credit for 68 days. I'm going to order that as soon as a bed's available at NeoCap, that you be released from the Lake County Jail. You enter NeoCap and successfully complete that program. Any balance of the jail sentence will be vacated. It's not a long wait for the female facility, so you should be able to get in there pretty quickly. You'll successfully complete that program, follow all their aftercare recommendations. Upon completion of NeoCap, you're going to be ordered, and you're probably not going to have to do this, but I order it in every NeoCap case, to return to the jail for 30 days for the transitional day reporting program. Again, you probably won't have to do this, but it's a program that helps people make the transition from being locked up to being on their own. Many people, when they get released from custody, have nowhere to go. They don't have housing, they don't have work, and they're lost. So it's a good program for that. But if at the time when you're released, you have all that set up and you don't need it, I'll vacate it. I won't make you do it. But it's a good program for those that need it, so I put it in place for everybody. Further conditions, you're not to use any drugs or alcohol. Includes marijuana. You're to submit to random urine screens. They have to be negative. A positive screen's a violation. To attend 3 AA meetings a week and have a sponsor. To obtain and maintain full-time employment. To obtain a mental health evaluation and follow all recommendations for any type of counseling or treatment, medications, take all medications as prescribed. You'd have one doctor and one dentist that could prescribe you medication, one pharmacy where you get them filled. Probation needs to know who those doctors and the pharmacy are. You can only, and you send whatever releases they want so they can contact those folks. You pay court costs and supervision fees. You'd have no contact with Jamie Vessel. Or the forfeiture of the contraband and instrumentalities. I will release bond. We're not forfeiting bond. It was revoked because of the positive screen. So it wasn't revoked because she failed to appear, so bond will be released. Ms. Crook, is there anything else I should be considering or think of?
No, that's it, Your Honor. Thank you.
Ms. Swope, you understand the conditions of your probation?
Oh, yes. Can I ask one question?
Yes?
Why no contact with Jamie Vessel?
Because he was with you that night and he's not a good influence.
He doesn't, okay. He didn't know I was using, that's all. He works
We
for
can pull all your messages up if you want and take a look at
works
them.
for the county. I understand.
You guys talk about it all the time.
His previous, he's been in recovery though, so.
Any other questions, Ms. Swope?
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, and the rules of probation. If you leave Ohio without permission from the court, or if you commit another offense while you're on probation, a motion to terminate your community control will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I sent you to prison, it would be 12 months in prison, which would be consecutive to any other term that you may be serving at that time or that you're being sentenced to at that time. You understand that?
Yes, Your Honor.
Mr. Teague, anything else?
No, thank you, Your Honor.
Ms. Tuttle?
No, thank you, Your Honor.